one of the things that many people don't know and don't, and there's no reason for them to understand, but that it's important to understand, is that unlike the 12 judges that sit in the district court in the sections A through L, they only get 1/12 of the cases that the district attorney decides to actually bring charges in. The magistrate judge, however, sees every single person who is arrested, even if no charges are later filed. Every single case begins in magistrate court, and every single person who is arrested on a state criminal charge that comes into the criminal court first goes through the magistrate section where bail is set. So there's an opportunity for a tremendous amount of impact given that fact. The other thing is that there are two main drivers of our system of mass incarceration. And as I think everyone in New Orleans knows, as I know Mr. DeBerry knows, our system of mass incarceration by far disproportionately affects people of color. And in New Orleans, that means Black people. And there are two main drivers of that. One is our sentencing law, but the second part of that is our bail law, is pretrial detention. And so the magistrate judge has a huge impact on one of the main drivers of mass incarceration, which is bail and our pretrial detention.
How exactly do our bail laws drive mass incarceration? What's the link between the first and the second?
The link is that in places like New Orleans, and certainly in New Orleans, for decades, there has been routine use of imposing money bail on every single person. Almost no one, unless they are wealthy and have special connections, gets what we call ROR, released on a personal promise to reappear. Everyone gets some sort of money bail. And most often they get a money bail that requires the use of a bail bondsman. And the way that impacts the community is that most people who are arrested and brought into the criminal justice system, frankly, are poor. Poor people of color are what make up 85, 95% of what comes into the criminal court. And so if we can put an end to money bail, we can stop holding nonviolent minor offenders who are no danger to the community and stop holding them in jail, which destroys their lives. And it not only destroys their lives, but it destroys their families' lives. And when done on the mass scale, we've been doing it in New Orleans, it destroys neighborhoods and communities as well.
I'm sure that you saw the statement that Chief Justice Burnett Johnson wrote a few months ago. It was shortly after George Floyd was killed in Minneapolis, where she talked about the systemic racism that exists throughout the criminal justice system. You've mentioned some of it that happens in the magistrate court level. You know, where are those other moments where racist policies are leading to a mass incarceration or the imprisonment of poor people or the imprisonment of people who wouldn't otherwise be there? Magistrate court, I'm guessing, is one of them, but it can't be the only place.
No, it's certainly not the only place. I certainly see it in sentencing, in adult court. There's huge sentence disparities between what white people and what wealthy people and white people, and people, quite frankly, who the way in which they commit crimes is white collar crimes, economic crimes, the kinds of sentences you see there versus the kinds of sentences imposed, even again on minor offenders charged with possession of marijuana, maybe multiple times, who have substance abuse problems, small time possession of even cocaine or heroin, theft, minor burglary charges. The sorts of sentence disparities we see certainly impacts. Another really not often talked about or discussed component here, where I think the magistrate section also can play a role, is in affecting police behavior. If police officers know that if they arrest someone, the person in magistrate court is just going to set a money bond on them, the person's going to be too poor to make that money bond, and they're just going to sit in jail where the DA has up to 60 days. in order to even file a charge. It's called doing DA time, what we've called it in New Orleans. If the police know that, then anytime they want to, anytime someone looks at them crosswise, doesn't respond to their commands, isn't cooperative enough, they know they can go ahead and just arrest the person and ruin their lives. And they don't necessarily have to have any intent to file a police report or pursue charges. That's the behavior we've been encouraging for decades and what's gone on for decades in the magistrate section. If they know in the magistrate section that person is going to get released, that there's going to be real scrutiny of what's taken place, of what the facts are of the arrest, of what the basis of the charges, that will trickle down to police behavior out on the streets and change that behavior because they know it's not going to work that way any longer.
How should it work? If we replace money bail with what? A person, it comes to magistrate court before you charged with, let's say, theft of a vehicle. And a judge, magistrates before you would have automatically set bail for that offense. How would you do differently than your predecessors?
I think that's a great question and a very important question. Ending money bail doesn't mean you just let the doors open for free. There are a number of cities. It's the city I practiced in as a public defender for 8 years, Washington, D.C. There was no use of money bail, and we had 99% return rate to court. And the way that was effectuated was by having very effective use of non-financial conditions of release, okay, which requires a good pretrial services agency. You can have check-in requirements where the person has to periodically check in person with a pretrial services worker. The pretrial services worker has access to their home and work information so that they can make drop-in checks, phone checks, okay? The other thing is to have the people quickly evaluated by people with expertise in mental illness and substance dependency. So if that's what's leading to, in your example, the car theft, substance dependency, get them connected with community-based substance treatment programs. Then there can be monitoring of the person to make sure they're complying with the requirements of the program. And if they're not, then bring them in and figure out, well, maybe we need inpatient versus outpatient treatment. Same thing with mental health. Have experienced mental health workers interview people at first appearances, identify those people who need treatment, and get them connected with community-based treatment. Because the fact of the matter is, in our jail, there is no effective drug treatment or mental health treatment going on there. So it's also, at the same time, much cheaper to do it this way, to connect people with community-based programs. And we actually solve people's problems that brought them into the criminal justice system. That's going to reduce recidivism, reduce the jail population and the cost to taxpayers, and increase the quality of life in our city overall, because we're actually going to be addressing people's needs, and we're going to be reducing crime and the level of criminal activity.
The courts in Orleans Parish, though, often depend on fines and fees and surcharges built into bail, and that is how the court has been funding itself. Your approach would necessitate a rather radical refunding or funding structure for the court system as a whole. What do you propose to replace what we have? And what would be the procedure of actually bringing that replacement into fruition? I mean, you could tell voters that, you wouldn't do money bail, but that wouldn't necessarily eliminate it all across the board. And I'm sure you would get some pushback from the current institution. So how do we manifest this particular change that you would like to see?
Well, as usual, again, a great question, very insightful question. I confronted this exact same thing when I took over the public defender's office post-Katrina. The public defender's office post-Katrina was run by pre-Katrina was run by the criminal court judges. We made it an independent office that they no longer ran. Believe me, we got pushback. I got thrown in jail many times by judges who were opposed to an independent public defender's office that represented its clients. And we faced the exact same funding problems. The funding stream for the public defender's office used to be based on fines and fees, assessed mostly on traffic offenses, but also on all criminal offenses. So we faced that exact problem. So there are a couple things that need to be done in order to create this kind of reform. And the thing I would emphasize is I've been through that, I've been there and I've done that before, and I can do it here. The first thing is that there are lots of sources of grants and alternative sources of funding. The first place to go is the Department of Justice, Bureau of Justice Assistance. Then there are also many private foundations across the country, especially now when in the wake of George Eliot and Breonna Taylor and the other events that we've had, criminal justice is now front and center across the country. There are plenty of private foundations, as well as the Department of Justice, who will fund programs to initiate this kind of reform. Now, the key here is initiate, because most private funders do not want to replace the government. So what you do is do what we did with the Public Defender's Office, which is you develop pilot programs and you ask for temporary funding for 2 to 3 years. And during this 2 to 3 year period, you can develop the system and get data from the system on results, show that it works, show that it saves money. And over a period of 2 to 3 to 4 years, you can then transition to full government funding of the program, which ultimately will cost the taxpayers less because you'll be saving costs from lowering the jail population, from reduced recidivism, which means police officers don't have to go out and rearrest people, and then the whole court system has to gear up again to deal with the same case and situation. We did that exact thing with the Public Defender's Office. It used to be funded exclusively by court fines and fees, and pre-Katrina, the funding was like 1.75 million, somewhere between 1.5 and 2 million. Post-Katrina, by the time I left, the funding was up to 6.2 million, and it was mostly from government sources. But at the same time, as we were reforming the Public Defender's Office, what's happened is the jail population went from pre-Katrina levels of 6,700, that's 6,700 people in jail, to now in the jail, there is 850 people. So you have millions of dollars of cost savings there that can be used for these programs. And at the same time that the jail population went from nearly 7,000 to under 1,000, the crime rate went down. So all of these things can be done at the same time because, again, as you know, Louisiana has been the incarceration capital of the world for decades, and New Orleans has been the incarceration capital of Louisiana. And for decades, we had that system, but yet our crime rate was astronomical. We had a murder rate in the 450 to 500 murders a year. Now we're more in the 100 to 120, at the same time that our jail population has gone through the floor.
The next question I was going to ask you is the particular situation of domestic violence, which magistrate court judges hear routinely. I'm sure that makes a significant percentage of the cases that come before magistrate judges. A recent Louisiana law requires judges to ask suspects in those cases, if they are in possession of firearms, et cetera. We have a low percentage, I think 30% of judges, as counted by Court Watch Nola, or magistrates, I should say, are actually asking that question. I want to, though, expand beyond that specific question and ask you, do you think that domestic violence cases deserve a different kind of treatment than the other cases that might appear before a magistrate? And if so, what makes them different, and how would you respond differently?
The direct answer to your question is yes, they do deserve different treatment. One of the reasons they deserve, I think one of the big reasons they deserve different treatment is the unique way in which they pose the potential for future dangerousness, for recidivism, for the same thing to occur again, and for it to escalate and get worse. One of the things you mentioned that only 30% of judges were even asking the question. The other thing that the Court Watch Nola reports, if you dig into them, discovered is that only 15 guns were seized in an entire year as a result of this. Now look, I've spent years as a public defender. That means I've been on the side representing the defendants in the case. And so you have a program, the law requires judges to ask the accused, do you have access to a weapon? And if so, you know, they have to give it up. And that's resulted in only 15 guns being turned in. I would propose adding something additional. And I don't need a law to get me to do this. I can just do this on my own. Having a law would be nice, and I'd certainly advocate for it. But how about making the police and prosecutors ask the victim if the accused has access to a weapon? If they're in a domestic relationship, the victim may well know if their domestic partner has access to a weapon, and you might get a very different answer, and you might get a very different response rate. So I think one thing you can do is require police and prosecutors not just to have the judge ask the accused, do they have a weapon, but how about let's ask the victim. Let's find out from the victim if the person has an access. Now, this is one of the other things about ending money bail that's very important. One of the key things of our money bail system is when you set money bail on everyone, what you get is what we've had historically in New Orleans, which is poor people charged with minor offenses get $1,000 or $2,000 or $3,000 bond. They don't have any money, they can't make it, so they're in jail, and we're paying taxes to keep them in jail. Then you have other people charged with violent crime, domestic violence, where they have a history of domestic violence, and they're repeat players in this system. They get a bond set maybe at $100,000 or $150,000, which makes the judge look tough. But if the person has access to $5,000 or $10,000, a bail bondsman is only going to be too happy to take that money, and that person gets out. So we have a backward system where we have dangerous people who are allowed out of jail by our money bail system, and we have non-violent, non-dangerous people who are in jail. I want to flip that around. So there is one thing that we have never made use of in New Orleans. In my 20 years in New Orleans, I've been here since 1999, I have never seen a prosecutor in magistrate court ask for a hold without bond, preventive detention. And that is constitutional, and there is a constitutional way to do that. The case is a 1980s case called United States versus Salerno, where the United States Supreme Court said preventive detention is constitutional. And so in domestic violence cases, I want to find out from the victim, through the prosecutor and the police, is this a repeat offender? Does this person have access to a weapon? What is the likelihood of future dangerousness? And if there is that, I don't care how much money the person has. If the person is dangerous, if they're charged with murder, rape, armed robbery, I'm not setting a high money bond, or again, repeat domestic violence, or a situation where the person is there's even one case of serious domestic violence where they pose a real threat. I don't care how much money they have. I'm asking the prosecutor to ask for a hold without bond, and then that lasts for 5 days. And then you have a hearing at which the prosecution can show by clear and convincing evidence that the person is a danger to the community. That person gets no bond. They're held without bail. I don't care how much money they have, they can't get out. So
Does
that's
the prosecutor,
the side of ending money bail.
does the prosecutor have to ask that?
The prosecutor does have to ask that and does have to make use for it. You know, I haven't looked under current law. That's the way it works. That's the way it's supposed to work, because really the police and prosecutors are the ones who are closest to the crime and the victim and know the defendant's history and record and have access to that kind of information. But there's nothing that stops the magistrate judge from saying, hey, I'm hearing what you're saying, DA, I'm hearing what you're saying about your record, this person's background. I want to pass this case. I want you to talk to your supervisors and have them look at this case more closely and see whether or not this case is an appropriate one for you to be asking for a hold without bond. There's nothing that stops the magistrate judge from doing that and encouraging that practice. And I think if we get that, once we get that practice running, it's never been used, and it's simply been a habit because they've been getting away with sort of this de facto preventive detention of just setting high money bonds and doing it sort of the lazy way out, rather than really scrutinizing cases and figuring out which are the cases where people aren't dangerous and can be released without any money bail. And then what are the relatively small number of cases, because it is a relatively small number, but they are the important cases that we need to focus on and spend time on. And those are the ones where you need a preventive detention hearing.
One question from the public here.
Sure.
Have you ever appeared in magistrate court and asked for the magistrate or the sitting judge to set bail or deny bail for someone accused of a crime?
I've never appeared in magistrate court as a prosecutor. So I'm never asking for someone to be denied bail or to be held without bond. That's the prosecutor's job. But I've certainly seen, I mean, when I ran the public defender's office from 2006 to 2009, one of the main reforms I did was I reformed the entire way the public defender's office operated in magistrate court. Previously, they didn't interview anybody individually. They never brought any information to the judge's attention about their employment, their family ties, their education, any issues of mental illness or substance abuse. They weren't even assigned a specific lawyer prior to Katrina. They were just sat in jail without any lawyer for 60 days to up to 150 days. So I've sat there and sat through thousands of magistrate court hearings, and we completely looked at the way magistrate court operates from the 10,000 foot view. And so I've seen how it operates overall over thousands of cases. So I can see how to change it even from the judge or prosecutor perspective. And as I said, they've never made use of preventive detention as a defense lawyer. I have no idea why. I knew that there were cases that were appropriate for that, where we were, as the public defender's office, were representing the defendant. And we'd sit there and we'd be like, we have no idea why they're not making use of it. As magistrate judge, my role would be to make sure that the vast majority of people, again, who are nonviolent get out without any money bail, and that small number we focus on, and we have constitutional hearings where you spend time, hour and a half, hours if necessary, to determine, is this person a danger and one of those few people, one of those relatively few people who should be in jail without bond.
How will that, taking, you said hours maybe, how will that affect the efficiency of the court or the efficiency of the intake process into the court system? Is what's going on now a matter of efficiency or money coming into the court, or a combination of the two?
Efficiency is one of those great words, and I'm very glad you used it. The Metropolitan Crime Commission, that I know Mr. DeBerry knows very well, they put out what they call efficiency reports on each section of court. But they are not efficiency reports. They are speed reports. They don't measure, efficiency is how much effort it takes and work it takes to do something well. What they measure is simply speed. How fast does the judge get through things? Which is not what we want in our criminal justice system. I know of no one, and Mr. DeBerry, if you are such a person, please tell me I'm wrong, but when you get on an airplane, do you ask the pilot and the stewards and stewardesses, how fast did you do the maintenance? Is that what you ask? I doubt it. I doubt any person wants to know that. They don't want to know how fast it was done. They want to know how well it was done. So efficiency and justice, you're dealing with people. You're dealing with witnesses, victims, accused people, some of whom are innocent, some of whom may have done something wrong, but not as serious as what they're charged with, and some of whom may be dangerous. And so efficiency means doing it well. So one of the problems we have is right now, our current magistrate judge sits on Wednesdays. He makes $150,000 a year and he sits on Wednesdays. I'm sorry, that's just not good enough. I don't think that's what the public expects. I don't think that's what members of the public who work experience. So the first thing is sit 5 days a week. How about sitting 9 to 5? I do not know any judges who routinely, day in and day out, sit and work on the bench a full 8-hour day. I'm prepared to do that. So sometimes it will take more time. Justice does take more time when done right. If you want to just lock up poor black people en masse, like we've been doing for the past 20, 30 years, that doesn't take much time at all. You know, traditionally, the magistrate judge comes in about 9:30, sees a bunch of lawyers in his chambers until about 10 or 10:15, takes the bench, runs through first appearances from like maybe 10:15 or 10:30 till 11:30 or noon, handles a couple other matters, and then is off the bench by 1 o'clock. And then there's an afternoon first appearances at 3. That's working 3 hours. We can, if you know, when I ran the public defender's office, I used to have a running deal with all of the reporters from the TV and newspapers. I said, if you find more than 3 judges sitting after 12:30, I will buy you lunch. This went on for 3.5 years. I never had to buy anybody lunch. Okay. I'm prepared to work a full day.
You've alluded to some of these issues before, but I want you to think a little more broadly about it. This is a question from the public. In New Orleans, the magistrate court judge is the front line for suspects to either receive or be denied justice in the criminal court process. Black people have particularly been denied fairness in this court. You've mentioned getting rid of money bill, but what are some other ways perhaps that racism might be addressed in the magistrate court? What else is required beyond what you've already stated, the elimination of money bill?
Boy, it is a great question from this member of the public. There are so many ways in which racism infects the magistrate court if you sit in magistrate court. It has to do with the way people who are first arrested are treated. Judges, I remember when we were reforming the public defender's office to try and interview all of the inmates, the magistrates and commissioners, they loudly objected because they didn't want to take the time to have each one of these individuals interviewed to learn about their background. Well, and who they were and where they came from and what brought them to court. That is racism. That is treating people disrespectfully, as not as individuals. The same thing is true for witnesses, for lawyers. I mean, one of the things I think that could be made much more efficient is to stagger court appearance times. So for example, the magistrate court also handles misdemeanor cases. Instead of having everybody show up at 9 o'clock so that the judge can make sure that the judge isn't waiting, how about treating people, because again, most of the people who are victims and witnesses are also Black and poor and come from the communities in New Orleans. So that's disrespectful. How about staggering it? How about saying, we're going to handle this group of cases at 9 o'clock. I'll have another group come at 10:30 or 11. I'll have another group come at 1. And maybe, yeah, the judge, some people won't show, and so the judge might have some downtime and might be waiting sometimes. But this way, lawyers, witnesses, victims, as well as defendants who are out won't be sitting in court waiting for 4, 5, 6 hours for their case to be called just because the judge wanted to make sure that their time was being used valuably and they didn't have to wait. So there's, you know, just the way people are treated, the way victims and witnesses are treated. Like you said, the law requires that the judge ask the domestic violence accused whether they have a gun. Well, why isn't somebody thinking about the victim or a witness? Did they see a weapon? These are all sorts of subtle ways in which racism plays a role, because you brought up the word efficiency, because there's this premium put not on efficiency, bringing justice and doing it well and taking your time and doing a good job and putting in a full day's work, but there's this emphasis on speed. And speed means you're treating people as if they aren't important all the way around the system. And so I think learning to take more time on each case and spend more time on the accused, the suspect, and on the victim and witnesses will bring a greater feeling of respect and fair treatment for everyone.
You may have seen that last year, Court Watch Nola reported that some people were being sent to jail, to prison on the basis of faulty drug tests. The tests were not proper or scientifically sound, but some of the judges and magistrate judges have continued to sanction defendants without proper testing. If you're on the magistrate court bench, how do you look upon a drug test, and knowing that this problem exists, what do you think is the proper remedy to it?
It's a great question. We have in New Orleans, when they brought drug testing to New Orleans, they have completely and totally distorted the purpose of drug testing. Again, in places like New York, Washington, Los Angeles, San Francisco, Minneapolis, Portland, the drug test should not be used as a basis to lock somebody up and incarcerate somebody. That is just a complete misuse of drug testing. The purpose of drug testing is to find out, does this person have an addiction problem? And if the person tests positive, whether the test is accurate or inaccurate, right? The solution is, the reaction should not be to revoke their bond and send them to jail. That is not the solution to someone with a drug addiction. What you need to do is, if you get a positive drug test, is connect them with community-based, meaningful drug treatment, okay? And you have to expect, I mean, I don't know how many, I'm an old guy, so I grew up in the 1980s. People still smoked a lot. And I used to have judges who had the worst smoking habit possible. And when someone would test positive for drugs, they'd yell at the person, again, almost always a black person, and yell at them for not stopping the use of drugs like the judge told them to, and then lock them up. We've got to stop that approach. If you've ever watched somebody try to quit smoking, it doesn't happen the first time. It doesn't happen the second time. It may not even happen the third or fourth time. Sometimes it takes 5, 6, 7 times. So what you've got to do with the positive drug test is not lock the person up and punish the person. You're punishing somebody who has a health problem, an addiction, right? That's morally wrong. It's morally reprehensible, and it's ineffective. What you need to do is keep making efforts at treatment repeatedly. And you might change the type of treatment, might go from outpatient to inpatient, might go from inpatient for 30 days to inpatient to 60 days or 90 days. You might change the treatment program to different types of treatment, but the solution is not jailing that person. So this idea of doing drug tests, and then when somebody tests positive, jailing them because they violated the conditions of their release, is just ridiculously ineffective. It's morally reprehensible. And again, who are the victims of it? Poor people of color.
We obviously don't know how long this pandemic is going to last, but there have been many complaints about the public not having the access to court proceedings that they previously had. Court Watch Nola in particular waited for over a month to have access to the Zoom proceedings occurring for bail bonds hearings, and they're still not as transparent as they ought to be. What is the solution to this problem, and how, even in public health emergencies, would you assured transparency and the public's access to what's happening in the courts?
It's a very serious question, and I'm going to answer it very seriously. I do just, but there's a lot of seriousness here. I do just have to note there's one person who would disagree with your assertion that we don't know how long the pandemic is this guy in the White House with orange hair who thinks he does know these things. But leaving him aside for one moment, I agree with the premise that we don't know. I do think transparency is very important. I think one of the things we need to do is, first of all, we need to return to having first appearances multiple times a day. Currently, they only occur one time a day due to COVID. They used to happen 3 times a day, in the morning, in the afternoon, and in the evening. So we need to return to that. And there needs to be access for everyone, for the whole public, not just Court Watch Nola, which should have access, not just the media, which, like you're part of the media, should have access, but the entire public. There needs to be a public way to have access to court hearings where any member of the public knows how they can watch via Zoom or via video link until we can start bringing people slowly back into the courtroom. I do also think we need to look at how we can set up the courtroom and how we can set up first appearances in a way where at least family members and victims and witnesses can be there socially distanced with masks and with proper protections. Certainly I've been in courtrooms since COVID around the state of Louisiana where they have it set up where the place where the witness sits has a clear plastic plexiglass barrier. The court personnel, including the judge and court reporter and clerks, are separated from the public, and the attorneys are separated from each other, but still people can, and then the public is separated and then socially distanced with masks. So we can certainly look at some of those ways to bring people back in, but at least until that can be done, I think the technology is there and we can overcome this with some technology and make sure that that everyone, the media, court watchers, the public, victims, witnesses, family members of accused people, of people who have been arrested, can all view the proceedings and see what's going on, because there needs to be that transparency. COVID and the existence of a pandemic, especially, it might be justifiable for the first 30 or 45 days while you're figuring it out. It might be justifiable, but we're now 6 months in here. It's time to get to figure out solutions so that everyone can watch what's going on in courtrooms that are required to be public by law.
We have reached just about the end of our time. You have, I should say, an opportunity now to do a 1-minute closing statement where you can tell people why they should vote for you.
Okay. First of all, thank you, and I appreciate this forum. I am very sorry and distressed that my opponent chose, for I have no idea what reason, not to appear at this kind of forum and answer these kinds of questions. I have some thoughts about that. My opponent is the candidate of the bail bondsman. She is the bail bondsman's candidate, chosen candidate, and she is going to be there. She is going to be there to maintain the status quo. I have committed that I will not take a dime from any bail bondsman, anyone in the bail bonds industry, or anyone associated with the bail bonds industry. And I think my opponent should be required to make the same commitment, because the idea that the bail bondsmen get to pick, I mean, it's one thing to contribute to other judges' campaigns, but to pick the magistrate judge who's in charge of setting bail, to me, is a complete conflict of interest. It should be prohibited. The magistrate judge should not be taking money from people who have a financial interest in the setting of bail. That's just wrong. And I've made that commitment. I would like to see my opponent make that commitment. She won't, because she can't. The reason people should vote for me is because I'm the one who has the proven record of bringing reform and major change, not just tinkering around the edges, not just small little changes, but big major reform. I have the experience of doing that successfully after Katrina with the Public Defender's Office, and I can do the same thing in the magistrate section. My opponent's not going to do that. Again, she'll talk about changes. She'll get the talking points, but in terms of really doing, of walking the walk as opposed to just talking the talk, she's been part of the establishment for the past 20 years. She was a commissioner in magistrate section. She's been in government in appointed positions throughout her career, and she has never once brought real meaningful change. So look, if you think that our criminal court system here in New Orleans and the criminal justice system is just fine the way it is, I am not your candidate. You do not need to vote for me. That's the other person in the race. But if you think our criminal justice system, that it's time for real transformative change, that it's time to stop the systemic racism, to bring an end to this broken, dysfunctional, racist, classist system, then I'm your candidate. And I can do that. As I said, I've been there. I've done that before with the Public Defender's Office. I can do the same thing. The magistrate court is much smaller than changing the whole Public Defender's Office. I can do it.
Well, thank you, Mr. Singer, for your time. I'm going to turn it back over to Liz.
Thank you so much to both Mr. Singer for participating and to our moderator, Jarvis DeBerry. We really appreciate you. I want to also thank you to everyone who's been watching and apologize. I know we had some technical difficulties at the beginning, but we got it up and running. So thank you for sticking with us. Thank you again to all of our co-hosts who have helped organize this. Court Watch NOLA, Innocence Project New Orleans, Southern Poverty Law Center Action Fund, Louisiana Courts Matter, National Council of Jewish Women, League of Women Voters, Orleans Public Defenders, Crescent City Media Group, and Urban League of Louisiana. Our next session in the series is tomorrow night at 7 p.m. when we will have the candidates for the Louisiana Supreme Court. So I hope you can join us then. And until then, everyone stay safe and take care. Thank you.
Thank you. Thank you, Mr. DeBerry. Great questions from you and
Take care. Take care.
Good night, everyone.
Good night.